Please be seated. Good morning and welcome to the first trial preparation conference. Before we start, I would like to give the photographers the opportunity to make some pictures. Please proceed. Thank you. Mr. Court Officer, could you please call the case?
Good morning, Your Honours. This is case number KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of a few rules to be observed at all times. Before speaking, make sure your microphone is activated and to switch it off when finished speaking. Speak slowly and clearly, as we have interpretation from and into Serbian and Albanian. In this way, the interpreters can do their work properly. And before intervening, wait 5 seconds in order to allow the interpreters to finish their previous sentence. I would also like to remind the parties and Victims' Counsel and the registry that certain information in this case is subject to protective measures and confidentiality orders. This includes confidential information that has been redacted from the confirmed indictment concerning the identity of certain individuals, locations, places, and other information. Confidential information shall not be disclosed in open session. I remind you to give me prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Now, I would kindly ask the parties, Victims' Counsel and the registry to introduce themselves, starting with the Specialist Prosecutor's Office. You have the floor.
Thank you. Good morning, Your Honours. Good morning, representatives of the registry, the defense, and the Victims' Counsel, and everybody present in this room and outside. The prosecution is represented today by Mr. Alex Whiting, Deputy Specialist Prosecutor. My colleagues, Filippo De Minigis, Associate Prosecutor, Silvia Dascoli, another Associate Prosecutor, and my name is Cezary Michalczuk. I'm a prosecutor for this case. Thank you, Your Honor.
Thank you. Now the defense, please. You have the floor.
Good morning, honorable members of the court. Microphone. Good morning, honorable members of the court, members of the prosecution, the registry, and the victims counsel. My name is Julius van Bonnet. I'm the lead counsel of Mr. Salih Mustafa. I'm accompanied by my team members. My team members are Mr. Betim Shala of the Bar of Pristina and Mr. Fatmir Pillai, who's investigator and support staff. Thank you very much, Your Honor.
Thank you. For the record, your client, Mr. Mustafa, is also present in the courtroom. Mr. Mustafa, I remind you that all rights under the law and the rules of procedure and evidence read to you by the pretrial judge at your first appearance continue to apply before this panel, including your right to remain silent. Now I turn to the registry. Please, you have the floor.
Good morning, Your Honours, and to everyone in the court. My name is Ralph Rich, the head of Judicial Services Division in the registry. I'm here with the registrar, Fidel Madonna. Thank you.
Thank you. For the record, my colleagues for trial panel 1 are Roland Dekkers, Gilbert Biti, Vladimir Midokola, and my name is Mappi Veldvolja, presiding judge for trial panel 1. I will give a short procedural history to introduce and give the legal basis for today's hearing. Oh, I'm sorry. Madam Victims Counsel, I'm very sorry. I'm very sorry. Please, you have the floor.
Good morning, Your Honours. Good morning, everyone in court, from the prosecution, the defense team, the registry. My name is Annie Poos. I am the victim's counsel. As you can see, at the moment, I am appearing here on my own. The team is yet to be assembled, but that will happen shortly. Thank you.
Thank you. And my apologies. To repeat, I will give a short procedural history to introduce and give the legal basis for today's hearing. On the 5th of May of this year, the president of the specialist chambers constituted trial panel 1. It is composed of the aforementioned judges and assigned them to the present case, as soon as the case file would be transmitted by the pretrial judge. On the 7th of May of this year, the pretrial judge transmitted the case file to the trial panel. And as of that date, the trial panel has been taken several decisions, including on the admission of victims participating in the procedures, on the nomination of experts, and on the review of the detention of the accused. On the 20th of May, the trial panel has issued a decision scheduling trial preparation conferences on the 9th, the 10th, and 11th of June, including 2 closed sessions. In the same decision, the panel requested the parties, Victims Counsel, and the registry to file written submissions on a number of issues with a view to gathering all relevant information to plan the next steps up until the commencement of the trial. On the 2nd of June 2021, the panel received the submissions as requested. Let me now inform you of the purpose of today's hearing. Today and the following days, we are sitting in what the rules of procedure and evidence call trial preparation conferences. These are hearings where we shall discuss on any issue that needs to be resolved prior to the start of the trial together with the SPO, the defense, victims' counsel, and the registry. Therefore, today, we will not discuss the guilt or innocence of the accused, and we will not examine the evidence. Tomorrow, there will also be an ex parte closed session with the SPO and units of the registry, and thereafter an ex parte closed session only with the SPO. The agenda for today is as follows. First, we will go through the issues set out in the decision convening the trial preparation conference to give the possibility, among others, to make observations. Secondly, you will be given the possibility to raise any other point you deem necessary. And finally, I will inform you of the decisions the trial panel intends to issue in the coming period. For the planning at a short period, it is my intention to continue till 11 o'clock. Then we will have a half an hour break till 11:30, and then another session of 1.5 hours. And then let's see where we stand. And if needed, we will have our 1.5 hour break and then afterwards continue. That's how I plan it for today. Okay? I see everybody nodding. Good. Before we start with point 1, I kindly ask you for the efficiency of procedures to adhere to the agenda as set out in our decision, and as far as possible to refrain from repeating what has already been shared in your written submissions. Okay, we will start with A, investigations and disclosure of evidence. The panel requested submissions from the Specialist Prosecutor's Office on the following issues. That is the confirmation that its investigations and disclosure of incriminating evidence are completed. And we had certain questions with regard to exculpatory evidence. The panel would like to hear if there are additional observations in this respect. You have the floor.
Thank you, Your Honours. I will be addressing this first part regarding investigations and the disclosure of evidence. I will not repeat, as you asked, the submissions that we made already. I need to add, though, a couple of additional information that surfaced compared to last week when we made our submission. We refer to the fact that we were preparing an application to the trial panel to add certain items to its exhibit list, and we mentioned the 2 additional interviews that we had with the prosecution witnesses. At the end of last week, there was a further addition, an additional witness interview, which will result in the addition of an extra witness to the prosecution witness list. And we will seize the trial panel in due course. We were planning to do that together with the application to add exhibits to the exhibit list, which will then comprise a request to both add exhibits, those that we mentioned in our submission, together with this additional witness. If Your Honours request additional information about this, this information can be given in the ex parte session that we will have later on. Also, as an update to what we have indicated in the written submission, the English and Albanian transcript of one of the 2 interviews we mentioned have been completed, so we expect to be able to disclose that depending also on the trial panel's decision concerning the commencement of the trial in due course. The transcription in both in English and Albanian of the other two interviews is ongoing, but as we said, we expect this to be ready no later than the 21st of June. Another update that I have as well, as we had indicated in our written submission, pursuant to additional material under Rule 102.3 of the rules, we indicated that the prosecution would file a further updated Rule 102.3 notice before the 9th of June 2021. We have not done that yet, and we will do it either by the end of this week or early next week, because an additional item surfaced as a consequence of last week's activities, and therefore we will be adding this additional item to the updated notice and file it together with the two ones that we previously mentioned. Again, if requested by the defense, none of the newly notified items will require reductions. These are the additional information that we have compared to our written submissions. If your honors have any questions or require me to go into the details of any of this information, we are available.
Okay.
Thank you.
Thank you, Madam Prosecutor. For my understanding, you were referring to the Albanian and Serbian transcript that had been completed. To what were you referring to? What interview?
Yes, I was referring to the English and Albanian transcript of...
the English, okay, therefore, okay, the English and Albanian transcript?
Yes, of the interview of witness 1679.
Okay. I look to my right. No questions here. No questions here. Okay, good. Thank you, Madam Prosecutor. Please, Defense Counsel, you have the floor if you would like to comment on what has been submitted by the prosecutor.
Thank you very much, Your Honor. Just a brief update other than what we have filed in our submissions is that we expect that in the coming month there will be additional material filed and disclosed. As it looks, the next mission is about to commence somewhere in the next week, and shortly after, at the end of June, will be the first part. When we disclose that, at the end of July, for sure, will be the second part, and if there is any rest material, then we will do that afterwards. So those are basically the issues. The timeline and the time frame that we have is pretty much remains the same for us. Just want to briefly note that we have divided our schedules, my co-counsel and me, and therefore we try to work as efficiently as possible regarding the disclosure of material and the filing and the filing thereof, actually. Other than that, Your Honor, thank you very much. We have no further observations at this point.
Thank you, Defense Counsel. I have some additional questions. The first one would be, do you have any comments on what the Specialist Prosecutor Office has just submitted?
No, Your Honor, I think there is no particular observation regarding that.
Okay. And
Yes.
with regard to the questions submitted to you in our decision, could you share, if possible, some more with regard to the nature of your investigations in the coming 2-3 months?
Yes. The nature will be, once again, that we will research some extra material. We will interview a number of people. And our schedule is also a little bit depending on the schedule of the people who we actually interview. But let me put it like this: we will work through the summer recess, and we expect that the last mission from my side would be the first week of August. Then I think we will have for sure completed our investigations. We have set as a really last date the 15th of August, but I assume that we will be probably be available to do that earlier. It's just that would be falling more or less just after the summer recess. The first court date, that would be the last cutoff date for ourselves, so to speak. Obviously, not always people are always available, and that makes it sometimes difficult to interview those people who do not necessarily stay in Kosovo. So that's why it can take a little bit more time or different time in our time schedule.
I understand.
But basically, that's our time frame.
And do you already have the trips
Yes.
to
Yes, actually,
planned? I mean,
yes, Your Honor. I'll tell you what the trips are. First of all, the first trip was that my defense counsel and my team came here. Just I thought it was a good idea to have everybody complete. My trip will be next week, most probably Wednesday, and then a week or 8-9 days lasting at the last. Then we expect to file material. Then in July we have scheduled a mission in the second and the third week, actually, and the last scheduled trip would be, as I say, early August.
Okay.
So that would be the first week of August. So the second trip of July and the one after, which is the first week of August, the material that we compile from that, we would like to disclose at that time, at the end of at the end of that trip. So it would be a week after the 15th or so, or around that time.
okay,
So
good.
But that pretty much we will most probably have by that time completed our investigations.
Okay.
Thank you very much. Yes.
Okay,
I
and then
remain standing.
Thank you for this. I have an additional question. Why these investigations have not been performed in the pre-trial phase already?
Yes.
We know that there have been some very pertinent reasons, maybe are those, but
Yes.
you have the floor for... because I thought they were finished when I was preparing in the pre-trial phase. Or during the pre-trial phase, I was reading the documents.
Yes.
And I was under the impression that everything had been done.
Yes. Your Honor, I recall that I had one time an ex parte session, and during that session I spoke about a number of issues, and actually that was the reason why it was delayed, or in fact started later. Without elaborating on whatever I have mentioned in that ex parte meeting, but that is basically what was the reason. That was the reason why it was delayed. I do not want to go into that issue right now, but I believe that I had only one ex parte session, and that was actually the reason why things were delayed.
Okay. Good. These are the questions for now from the trial panel on this point. Thank you. Mr. Prosecutor, Madam Prosecutor, do you want to comment on the specific issues the Defense Counsel shared with us with regard to the investigation?
No, Your Honor. I don't have anything further.
Okay, thank you. Then we will go to the next point, the site visit. The SPO, Victims' Counsel, and Defense Counsel have given their observations, while the SPO and the Defense Counsel expressed doubts with regard to the usefulness of a potential site visit. The Victims' Counsel favors it. Do any of you wish to make further observations with regard to this point? You have the floor, Mr. Prosecutor.
Thank you, Your Honor. Just to reiterate one point, that if it is decided that this crime site visit is indeed necessary, and if the trial panel decides that it will assist the panel with making their own assessment about the case, about the location, about geography of the place, as we said in our submission, we would be advising to organize it at the end of this trial, after the prosecution and the defense have already presented their arguments. So the reason for that being that the court will already have before them a pretty good and solid understanding of the case, and if that visit takes place, the judges or the judge who will be delegated to perform such a site visit will be in the position to understand where the buildings were in April 1999. Currently, there is nothing there to see. That's why it's so relevant to understand the case first and then go there and picture the place for your honors.
Okay.
Thank you.
Okay, thank you. Now let me turn to the Victims' Counsel. You have the floor.
Yes, thank you, Your Honor. I have already expressed that I am in favor of a site visit. I do welcome the suggestion by the specialist prosecutor to potentially do this after the prosecution case has been finished. Let me just add why I think this is so critical. Visualizing where suffering took place. Visualizing how perhaps the cold, the heat, the darkness, how all this might have felt to an injured body, to an injured soul in some cowshed, if the allegations in the indictment are indeed correct, will be something that will be relevant for the responsibility and for the guilt that the trial chamber has to judge about. Therefore, I think, yes, this is important, and I think also it's important that it is not just the parties who have an image in their minds, but indeed, and this is where we need to perhaps leave some of the adversarial mindset procedurally behind, where everyone involved needs to have that image. So therefore, I continue to welcome such a site visit. Thank you.
Thank you very much. Defense Counsel, you have the floor.
Thank you very much, Your Honor. Well, we don't see anything in crime site visit. I spoke earlier about an alleged crime site visit, but in the terminology that we use here, it should be regarded as the same, obviously. I think both prosecution and the defense have provided a lot of material which give, I believe, a very good insight in how it looked like in that time. As for a visit right now, there is nothing to see. So if there is hardly, there's one little building standing, which is, in my perception, irrelevant building as far as the alleged indictment is concerned. But nevertheless, if we see that site, which we did by video, three-dimensional, meter by meter scale representation, we have the photographs of the prosecution who have, from all types of angles, shown that. So I think that we are more than enough prepared to go on trial without a visit necessary. If the Victims' Counsel would like to visit the crime site, she's more than welcome to do that by herself, like the prosecution and the defense did. But I do not think that there is any particular issue which leaves anything undiscussed or unnoticed or whatever. I think, once again, both prosecution and defense provided more than enough material regarding that. So basically that's our standpoint. We have submitted that as well. If there would be any visit, regardless of the logistics, I think that's another issue. If that would take place, I think actually then that should need to take place before any witness is being heard, so that any witness who speaks about particular buildings or something, we have the material, we have the space, and so on. In that case, that would need to be taken place before that. Simply because I do not believe, the defense does not believe, that when we do this at the end, and there is questions or how or this or that, no, at that time, we can in fact propose to a witness or confront a witness or speak to a witness about that particular issue, having visualized it beforehand. But I therefore think that it is important that if such decision would be taken, then it be done before any of the witnesses being heard. And the defense also would like to participate in that case, like any other party, of course, should participate in such a visit. So basically, we stand with our viewpoint, and I do not have anything to add. I thank you very much, Your Honor.
Thank you, Defense Counsel. Then I conclude on this point B. However, I would like to go back to point A with regard to the request for an extra witness. In that aspect, I would like to know if you would be requesting protective measures for this witness.
No, Your Honors, we will not be requesting protective measures.
Okay. Okay. Thank you. Thank you. Good. Now, let us turn now to point C, conduct of proceedings in our decision. It includes 7 items, and I will go through each of them in sequence. The first topic, the commencement of the trial and the opening statements. The trial panel has received submissions by the parties and Victims' Counsel as to a tentative date for the commencement of the trial and as to the intention to make opening statements, the order and the moment to give opening statements, and the duration, and whether visual aids will be used. We have taken due notice of that information, and we would like to give you the floor if anything should be added. Mr. Prosecutor.
Your Honor, this point is included in our submission. However, for the sake of the public, I would like to say that out loud anyway. The SPO requests that the trial commences already in July. We indicated the date 12th of July this year, with the procedures required by Rules 124 and 125, and the opening statement by the prosecution. And this should follow by the presentation of the evidence by the SPO, starting already from the 15th of July, or we would call for the date around 15th of July. The prosecution is planning to examine 2 prosecution witnesses before the summer recess, and it will continue with hearing other prosecution witnesses shortly after the summer recess in September. So this is our position. However, if Your Honors decide otherwise, that the opening of the trial or adducing of evidence should commence in September, we would kindly ask that the opening speech as well as the prosecution witnesses are, the opening statement is made and the prosecution witnesses are heard from September. If we cannot organize it earlier in the dates that I have already provided, as one package, we simply don't want to separate the opening argument from the evidence that we will be adducing. And if necessary, Your Honors, I'll provide specific reasons during the session that deals with security later on tomorrow. Thank you very much.
Yes, thank you, Your Honours. As already indicated, from the point of view of victims, it is preferable to start after the summer recess. I should add, though, that obviously victims want to see justice done. They waited for 22 years, and we therefore welcome very much the opportunity to start, and to start with this case adequately prepared in a thorough manner and as efficiently and effective as possible, which of course is in the interests of all, and fairness of the proceedings have to be paramount. However, for me, it is necessary to go on a mission which is not only in my hands. It's nothing I can just book and go and do, but it's something that will require rather complex organizations because of protective measures in place. And this, therefore, is an entire machinery in the background that needs to work. Doing so is, however, necessary for me to be able to fully and comprehensively represent the views of those I stand for, which is an entire group of people I have to speak for. And therefore, for a meaningful opening statement from my side, it is necessary to have some more preparation time. Also, I should add that, in my view, the advantage of starting after the summer recess is that we, in that way, all fully prepared, can go straight into medias res rather than having a small portion of the trial starting and then with a break, having then a full, long, comprehensive trial proceeding seems to me preferable. Thank you.
Okay. And thank you for that, Victims' Counsel. And the opening statement, when would you intend to present it?
Well, obviously, this would depend on when we do start. If the trial chamber decides to go ahead in July, I might have to defer, depending on all those unknowns yet. Otherwise, I would be happy to present the opening statement at the beginning of the trial.
Okay. Okay.
Before, right after the prosecution presented theirs.
Thank you for that. Yes, let me turn to the defense now. The same questions or the same observations were asked to the defense. And in addition, I give you the floor, although you already commented on it in your observations on whether the accused intends to make a statement pursuant to Rule 142, paragraph 1 of the rules. You have the floor.
Thank you, Your Honor. We will make an opening statement. It might be rather lengthy, but that is because I have included that exactly that possibility that the accused would make such a statement. So therefore, please do not think that I will be 7 hours talking. I mean, that is not going to be the case.
It's your opening statement.
Yes, no, that is true, Your Honor, but I do not tend to speak like in speeches like so long. I can follow the prosecution in the sense that they would like to have an opening statement and then say, well, afterwards we start with the witnesses. That is an understandable thing. We do not agree on the time frame. We think that is too short notice rather than, and we have already planned some missions in that period that would really make it very complicated, our work to divide that part. So that is why we do not prefer to start on the proposed date of the prosecution, but rather than start right after the summer recess. I think it's basically we will be having an ongoing thing rather than partition all kinds of elements of this of this trial. I think it's a more logic order to do it as much as possible in a row. I think victims need to be prepared, or witnesses need to be prepared, all kinds of things that need to go on. So I think it's better to work out first those details as well before we start. And I think that before the summer recess, I think all these things would be better in place. In fact, if I mean, I speak about familiarization, about logistics regarding witnesses. I think it would be quite a task. I think probably an impossible task to do that all before the 12th of July. Disclosure would need to be done actually at the beginning of next week. So I do not think that that is a good course to go. It's better to move it after the summer recess, and once again we will not have any partition regarding that. Is there anything else regarding that issue? No, Your Honor, I think I've covered it. Thank you very much.
Thank you, Defense Counsel. The trial panel will issue a decision in due course on this matter. Let us move to the next item, that is point 2, the familiarization of witnesses prior to testimony. We have received your observations. Thank you for that. The panel has noted the proposal by the SPO for a familiarization protocol. And in this protocol, the parties, Victims' Counsel and Registry should consult, I saw, to the extent possibly to consult and to jointly file, as far as possible, observations for this protocol. The trial panel will invite you all now to comment in addition to your observations in writing, but especially the Victims' Counsel and the defense on this proposal of the SPO. The prosecution has the floor on the familiarization and related issues.
Thank you, Your Honor. We have listed all our arguments and our position, I believe, in sufficient detail in our submission. If Your Honor has got, or your Honors have got any questions, maybe for clarification of our position, I'll be very happy to respond to any such questions. If not, I would like to say that this is our proposal as a complete one. We will be very happy to engage with the registry, with the defense and with the Victims' Counsel on the possible agreeable parameters of such a protocol regarding both witness familiarization and also how to proceed with the review of the prior statements of victims. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Victims' Counsel, you have the floor.
Yes, Your Honours. In my view, indeed, it is. I welcome the prosecution proposals, and I think, indeed, we might have to liaise on a case-by-case basis, depending on the witness in case. Obviously, I can only speak for those that will have dual status, as those are the ones I represent here as victims. For me, it is utterly important that we do whatever we can by familiarizing, by introducing those victims to the court in a manner as humane and respectful as possible, because it is a daunting setup, and I am sure that together we can work our way through that. At the moment, I don't have any more observations to make on that.
Thank you, Victims' Counsel. Good. Let me turn to the defense. You have the floor.
Thank you very much, Your Honor. Actually, we have had yesterday a meeting with the prosecution's office, and this topic came also about. So we gladly engage in any kind of protocol or whatever. More in particular, I think it is always useful, as it is the practice at the ICC very much, that there is sometimes a kind of a report from the WPSO, in this case, about whether the person is fit to testify, whether he has any issues that we as parties should be aware of when we need to be aware of that. But when there is in-court or near-court assistance, as I always call it, just in order to make sure that that would go smoothly. I have, from my own experience, had occasions in which witnesses can become complicated, and those complications should also be reported at that time by the WPSO, I believe. In no case a court can be held hostage by a particular witness because he has particular demands. And I've seen in many previous cases that sometimes people seek asylum or whatever reason before it becomes a witness, as the witness is supposed to be a witness. So just I want to make sure that we have we are alert of anything, and that is why I think it is always useful to have some kind of report to the parties and the panel, of course, foremost the panel, that there are no particular issues regarding the witness, his demands or his needs, especially his needs, I would say, that might impair his testimony. What we all want is that at the end of the day, a witness is in court or via video link, but that he appears and that he is able to question himself, and that we as parties can question him. So all to say that I think it is useful that there is some kind of familiarization protocol in place, and also that it is reported afterward that, you know, everything is fine, go ahead, and there's no problems. Thank you very much, Your Honor.
Thank you, Defense Counsel. Now, at this point, I would like to move to item 3, the dual status witnesses victims. The SPO and Victims' Counsel have been asked whether they have exchanged information, including with WIPSO, relevant to identify which participating victim is also an SPO witness. According to the submissions, that has been dealt in a satisfactory way, as I understood. However, the trial panel is interested to know, as far as possible, in the result of this exchange. So I would like to give the floor to Mr. Prosecutor on this matter.
Thank you very much, Your Honor. Indeed, we have been engaged with the Victims' Counsel in the preliminary discussions on those dual status witnesses victims. And I would like to use this opportunity to make reference to one of the previous points that we made about the commencement of the trial and contacts of the Victims' Counsels with the victims. Our office will do our utmost to facilitate those contacts, if necessary, before the dates that we mentioned already in June and July I don't want to delve into specifics of the dates because, of course, we are talking about certain security considerations when it comes to those contacts. Most of these persons are in Kosovo, and we don't want to put them in unnecessary risk. But we will definitely assist the Victims' Council with her contacts with those persons. Thank you.
Okay. And if I understood well, you just said preliminary discussions, so there has not been exchanged or organized anything yet on this point.
We haven't organized the most important thing, namely the meetings, in-person meetings between the victims, witnesses, and the council. So this is what we have not still done.
Okay. Victims' Council, you have the floor.
Thank you very much. Indeed, you rightly heard the word preliminary. This is an ongoing dialogue which hasn't been completed yet, and I understand that it is a very complex matter, and hence I can't comment any further at this point about this.
That's also an answer. Good. Point 4 on our agenda, the presentation of evidence, witness evidence. Let me see, yes. Regarding this issue, the SPO was requested to provide submissions on the examination of witnesses and admission of prior statements. That's a short summary of what we asked. The Victims' Council was requested to make submissions on her intention to submit evidence and to call expert witnesses. And the Defense Counsel was requested on his intention to present a defense case, and the same questions we put to the SPO on witnesses and admission of prior statements. Does any of the parties or the Victims' Council want to make additional statements on this observation on this point? Mr. Prosecutor?
Not really. Just for the benefit of the public, again, I should say that the prosecution will call 14 plus 1 live witnesses. About this additional witness, we'll talk during the closed session later on. When it comes to one witness, as he is no longer available to give live in-court testimony, we will simply move to admit his previous statements, and the items we are looking at are no more than 15. Thank you.
Okay. Thank you for that. Victims' Council, you have the floor.
Yes, it has yet to be fully determined from my side, an expert witness, possibly on the psychological effects of those experiences that some of the victims had to endure. Yet, this of course comes with its own burden on victims, and therefore is a measure that really has to be very carefully thought about, and therefore this process is one that can only be fully determined after having been able to meet in person, face to face, because it is a human side that is involved here that requires very, very careful consideration from my side.
Okay.
But
So
I will let you know as soon as possible, because I don't under any circumstances want to delay anything there.
that is very good to hear with regard to the delay or not wanting to delay. So if I understand well, you say we might call an expert witness on, but that is to be decided after having talked to the victims. Okay, good, clear. Defense Counsel, you have the floor.
We have no other observations regarding this issue, Your Honor. If there is another expert witness coming, then obviously the parties will be able to question the witness. And that's all. And if there is an expert, then there is one. And if there is no one, then there is no one. So other than the observation that we made, there are no further observations. Thank you very much, Your Honor.
thank you for that. This hearing of today is also to add and not to repeat, so it's good that sometimes we highlight specific points that are important for today and also for the public, and some things we have been clearly explained in your submissions, and we have taken due notice of that. Point 5, the order of appearance of witnesses and issues related to the questioning of witnesses. Yes, for the SPO, we have received your submissions on appearance, whether the list is final, modality of witness testimony. The panel wishes to know if the SPO can give some more information on the order of appearance of the witnesses before it is known when the trial will start. You have the floor, Mr. Prosecutor.
Good morning, Your Honors. The SPO stands by its submissions also with regard to this question. We would be in a position to finalize the list once the trial date is set, but we would be happy. We can perhaps provide Your Honors with more information during the ex parte session that will follow this public session.
Good.
Yes, and on this point, the prosecution has nothing further to add on the order of appearances and their sub-points, unless Your Honors have any question about it for us.
Not, we don't have, thank you, but good. Does the Victims' Council have further observations on this point?
Thank you. At this moment, not. Thank you.
Okay. Now, the submissions on the questions that were of a similar nature for the defense, you have the floor if you want to add.
Yes, Your Honor, thank you very much. Just as our investigations are ongoing, regarding the order of the witnesses, we will have at some point an idea about which more or less go within the same line. So what we try to do is we try to group more or less the witnesses so that I think all the parties will have a kind of a logical order with what we are busy with, and that we don't need to go from one particular witness to obviously entire other witness. And also we will obviously go back to our witnesses in order to see, obviously for their time schedule, whether they are available within a particular time frame, so that we can provide such a grouping. So I think it would be only logical, and it becomes more efficient when we are busy with a particular issue which concerns particular witnesses which are in line with that issue. So that is what we are trying to do. We will obviously have a result around when we have heard the last witnesses, but I'm sure that at the end of the summer recess, we will be able to provide some kind of grouping for that. Yeah. Thank you very much, Your Honor.
Yeah. Kind of making blocks would be favored, yeah, in your view, yes. Okay, good. And we have...
I speak for the defense.
Yes, yes, that's what I tried to summarize.
Obviously to clarify things, yes.
And I have one more question in this respect. The trial panel wishes to know whether the defense could provide updated witness schedules in the event the order of the witness changes once the defense case commences, by email and on the regular...
Of course, Your Honor, we will. Yes.
Okay. Yes, we have received submissions on the scope and mode of questioning of witnesses by the parties and the Victims' Council. We have duly read them, and but however, you will get the floor if you would like to add something on those points.
Your Honors, not at the moment. We stand by our submissions, which we believe sufficiently clarify our position on the issue. Thanks, Your Honor.
Thank you. Now, the Victims' Council, I see her nodding, and I say that out loud for the record.
Thank you very much. At the moment, nothing to add. Thank you.
The Defense Counsel, you have the floor.
No, Your Honor, this particular issue, we have made our submission clearly, I think, and our observation other than that is that we believe that the rules actually do prescribe that the parties will go in particular order, and we believe that that is the way to conduct these hearings. We believe that the rules concerning that issue are imperative to all the parties and to the court. Thank you very much.
Thank you, Defense Counsel. In addition, I have two specific questions for you. One is the Specialist Prosecutor's Office made a proposal in paragraphs 35 till 37 of its submissions on the use of a list of documentation to be used during examination and cross-examination. It seemed to me in line with your proposal under paragraph 38. But for clarification and confirmation, I ask this question to you.
One of those rare occasions that we agree with the prosecution, Your Honor, is in this particular case. No offense. No, just that I think it is just useful that we do that shortly before, whenever that is to be determined. Obviously, there is always some issue that, you know, might come up on the last moment or so, and then I think we can give each other a little bit leniency regarding that. But in general, I think it would be useful to provide it beforehand, and it's also useful for the people of the registry and the court officers who can prepare and say, okay, this and that is going to be done. We will have no problems with it. I think it will be only more efficient in that manner.
Okay, thank you for that. And I have another question
Yes,
for you. Could you give some clarification for our understanding on the remark in your proposal in paragraph 38 that most of the documentation, I will read it out to you, so that's easier, that most of the documentation will probably be evidence that has been tendered.
Yes.
And now, the question is, what situations do you envisage where the documentation will not have been tendered? And do I understand well that you mean that these are undisclosed documents that are not in legal workflow? Is that what you mean?
If there might come up some particular document at any time of the stage of the proceedings,
Can be everything.
Obviously, we need to have a possibility to file that or disclose that material if that would benefit a particular witness. It can be because a witness comes up with something, for example, or whatever it is. And in that case, I believe it would be useful that we have in such cases leniency. All the other documentation, as far as evidence is concerned, are obviously in the case file, so which are in legal workflow. Is that an answer to your question, Your Honor? Yes.
Thank you,
Okay.
Defense Counsel. That answers my question.
Yes.
Yes, that answers my question. And what I understand that this proposal is would be for very exceptional cases, not the day before that we receive a list of 20 documents.
It can be only one item, or some kind of miscellaneous thing that suddenly came up from wherever it came. Some issue that is in the actuality regarding something. We must be able to be flexible on those occasions.
I have understood. Thank you. At this point, I would like to move to point 6 on non-oral evidence. Are there any further observations on the admissibility of any non-oral evidence under Rules 102 and 104 of the rules? I take it all together, and then you have the floor.
Your Honor, no, not at this time. Thank you.
Thank you. Victims' Counsel, you have the floor.
Yeah, Your Honour, no, thank you. No further observations to make.
Thank you. Defense counsel,
No further observations, Your Honour.
thank you for that. Yes, then the third issue of this same bullet is as to whether the trial panel should decide on the admissibility of the evidence at the time of its submission, or if it can be deferred to the judgment. I note that the SPO, Victims' Counsel, and the Defense Counsel have, if I may say so, concurring views on this point. Anyhow, are there any further observations on this issue?
Your Honor, no, but for the fact that we are very strongly in favor of admissibility being determined at the time that an exhibit is tendered. And to the extent that the court would require additional information to make that determination, procedures such as those adopted at the ICDY, where an exhibit was marked for identification, could be adopted.
Thank you for this addition. Victims'
Thank
Counsel, excuse me, you have the floor.
Thank you, Your Honour. Nothing further to add there. It's a good point that the prosecution has made there. Thanks.
Okay. Defense Counsel, you have the floor.
Nothing to add to our submissions, Your Honour. I think the point is clear.
Yes. At this point, I would like to move to point 7, judicial notice of adjudicated facts under Rule 175, paragraph 2 of the rules. The first issue, the trial panel asked submissions on whether the defense and the SPO have been discussing the possibility to request the party to take judicial notice of adjudicated facts. I understood that such discussions have yet not been finalized, and I would like to receive an update. So I give the floor to start with the SPO.
Yes, thank you, Your Honor. We met with Defense Counsel, with the defense team yesterday, and had a general discussion about this issue of the adjudicated facts.
Yes.
Of course, the adjudicated facts are not like agreed facts where we are seeking an agreement on these matters. So it was a general discussion, and we have proposed to, before filing, the prosecution will be filing its motion, and we will be informing the defense beforehand of the facts we intend to seek judicial notice of. And this is this was the extent of our discussion, and for the time being, no further communication apart from these are planned.
Okay. Okay. Thank you. Is there something you would like to add, Defense Counsel?
Oh, Your Honour, I think that probably an ongoing discussion, and at some point we will get to an agreement or a disagreement, and then we'll
Communicate.
It will be in the, yeah, obviously. Thank you very much.
Good. Then the second issue, we asked submissions to the SPO on judicial notice of adjudicated facts, but more specifically. And with reference to your submissions, Mr. Prosecutor, we have two further questions. Firstly, if you can anticipate which facts you would request to the trial panel to take judicial notice of. We have read some of it. Secondly, when such a request could be made in the coming weeks, and if not, why not? And any other submissions?
Yes, thank you, Your Honor. With regard to the adjudicated facts we'll be seeking judicial notice of, we haven't yet finalized our selection, but they will be concerning the existence of an armed conflict in Kosovo at the time. The prosecution believes that it would be against the judicial economy to have to tender evidence about the existence of a conflict which has been, the existence of which has been reliably adjudicated in several trials now. With regard to your second question, the SPO believes it will be in a position to file this motion by the end of the month.
Good. Thank you very much. Yes. Also, the defense were asked to give submissions on this issue. And with reference to the defense submissions, the trial panel has some further questions for you too. Firstly, the trial panel wishes to know if you can give an indication as to what adjudicated facts, from which proceedings, and how many you intend to put before the trial panel for judicial notice. And our second question is if you could present your request already in the coming weeks, and if that is not possible, if you could share your reasons why that could not be done. And then thirdly, you have the floor for any other further observations.
Your Honor, thank you very much. Obviously, we will try first to get agreement on adjudicated facts with the SPO. That would be most useful, I think. They make their list. We have probably another list, or whether we want to use that or not. I cannot give an indication on how many of that would be. We have not really discussed those points yet. So I think if it comes to mind, it would be at the end of the month or so that we could, for example, say whether we have any adjudicated facts that are to be filed as far as the defense is concerned. But in the first step, we will try to see what is it that the SPO has and whether we can agree on that, because otherwise we are, doubling our effort, and it makes no sense to do the double work. So, if in sum, we'll seek to see whether we can agree on adjudicated facts with the prosecution office, and if we have to add anything to that, we will. And if we can simply not agree on those issues, they need to be litigated. It's as simple as that. The issue that we discussed also briefly was the issue that the prosecutor just brought up. And the question is whether it is actually a legal fact or an adjudicated fact as such. So that's why we have not yet given thought about that. But I think, to give you a timeline, at the end of June, I think we would be able to present that if we wish those facts to be seen as adjudicated facts.
Okay.
Was my answer clear?
I will make a further question on this topic. You will try to propose by the end of the month a list of, or make a summary, a list of facts you would like the trial panel to take judicial notice of.
Yes.
Yeah.
Whether we want to
Whether, but not a list.
No. I mean,
and would you
whether we want to do that, and if so, which.
Okay, then there will be also a which. If there will be an, if the F is for the affirmative, then there will be also a list.
Exactly. Yes. And in the preliminary step, we will try to communicate with the SPO in order to see whether they listed issues that we can agree on, so that we do not do the same work together.
Okay. I leave this, this exchange between
Obviously.
you, of course. That is clear for me for now, but it's good to have a timeline and also on, for the end of the month.
Yes.
Good. Because for now it was kind of indefinite, and that was difficult to work with in our planning.
We seek obviously issues that have been in legal workflow, and that's what we are trying to determine, obviously, outside legal workflow. There is a large amount of jurisprudence that might have facts that could be seen as adjudicated facts.
Good. Now, for us, it's important the timeline, and I see that you both are
Yes.
prepared to do that by the end of the month. So
Absolutely.
that's important for us to know. Good. Nothing to add on this point anymore. No, eh?
No, Your Honor, not this time.
Okay. Good. Then, yes, these were the issues set out in the decision on the trial preparation conferences. However, there is another point raised by the defense that should be discussed here. In the written submissions, the defense raised the point whether and how, when defense team members or the accused are participating via video link, they can have a proper privileged conversation with their client. Yeah? I have asked Mr. Rush, Head of Judicial Services of the Registry, to give information in this regard, and he is present here. Mr. Rush, you have the floor.
Thank you very much, Your Honour. In summary, this can be facilitated. If there is a necessity for Mr. Van Bonnet to have a privileged conversation with his client, that can be facilitated, essentially by telephone. So there is a mechanism whereby, if the panel ordered a short recess for such a conversation to take place, if one participant was not physically present in the courtroom, we would essentially ensure that there was a privileged telephone line which would be available adjacent to the court, so it would not involve any technical delays or any implementation measures. It is something that could be facilitated very, very quickly. If you'd like some more details, Your Honour, I can provide those, but in essence, it can be facilitated easily.
Okay. Thank you for that. I will give the floor to the Defense Counsel, and he might add to your some additional questions. Thank you for that.
Thank you, Your Honour.
Yeah, it's just, Your Honour, that in these brief recesses, sometimes it happens that I'm with my client and discussing maybe something or some issue for after the recess. It can be sometimes a 15-minute break or whatever break. And then in that particular case, if other participants would not be available, I would like them to be available if, for example, any of the other participants would be via video link there. If that possibility exists outside court, but in the building, that is actually...
So, okay, so that's what I also understood, that you will be talking as a group of 4 people. That's what...
Yeah, 3 or 4 people.
3 or 4...
Yeah.
So you, one of your
team
members of the team,
and
Mr. Mustafa.
Yeah.
So a kind of Zoom meeting. With
not necessarily Zoom.
No,
I mean, for example, if I'm present in the court, and for example, Mr. Salih would not be in court, for some reason, he would join via video link. And I would meet with Mr. Mustafa just outside here. How would he be able to participate in that?
I will give the floor
that is the
to
question.
Mr. Rush.
It's just a practical matter.
No, yeah, it's practical, but it touches upon a very important right for the defense. So, Mr. Rush, you have the floor.
Thank you very much, Your Honour. Outside the courtroom, within the confines of the courtroom, there is no mechanism to have a Zoom or audio or video conference. We had envisaged that this would happen via telephone, via secure telephone. It is possible to have a number of people on the same telephone call, so 4 or 5, whatever is necessary. But in terms of having a Zoom or a video conference meeting, that is not something that can currently be organised at short notice.
Thank you for that.
So I understand it's through telephone conversation that somebody else is participating then, whether it be my own interpreter or whether it be my co-counsel or if he's here and I'm not here. I mean, things can happen. So just to have that possibility.
Yes. Okay. But one way or another, there will be the possibility. There must be, of course, the translation also provided for. So we will have have my microphone on. So we will have the other person at the phone, the other team member at the phone, with a translator.
Thank you, Your Honour. If translation is required, we will ensure that that is available.
Okay, and that can be organized. Thank you.
Thank you very much. That concludes for us our question.
Good. Thank you for informing us. At this point, I would like to ask the parties and Victims' Council if they have other issues that they would like to raise.
Your Honours, at this point, for this session, we've got no other issues to raise.
Okay.
Thank you.
Victims' Council?
Just very, very briefly, a practical measure of trial proceedings. We have spoken about the potential start date, and it's very mundane, but if there is any indication of which days of the week you might intend to hold court sessions, that would be most useful for a lot of planning that has to go around this. So any indication that you could give would be very welcome. Thank you.
We have taken due notice of your remark, and we will try to be. We will try to make a planning a schedule as far as possible, of course. But in due course, because of course we have been discussing this already, and it's of importance for everybody present in this courtroom and also outside this courtroom for arranging. And there are of course other panel. And other panels who might be using this courtroom at a certain moment in time. So planning is one of our important issues we have to deal with. So, yes, good. Defense Counsel, is there something you would like to propose?
Observations, Your Honour. Thank you very much.
Okay, thank you. The parties and the Victim Council can indicate in writing to the trial panel, and of course we still have to make a decision on when we start, but as a general remark, I would like to say that if you think another status conference, or as it is called, a trial preparation conference is needed, please indicate it to the trial panel. And finally, I inform you that prior to the opening of the case, prior to starting with the trial, the trial panel intends to issue the following decisions. Of course, a decision with regard to a tentative date for the commencement of the trial, a decision on the establishment of establishing the rights of the victims participating in the procedure. There will be a decision on that, and we will issue a decision on the conduct of proceedings. And as a proposal from this side, the SPO and the defense could see if they could make a joint filing on adjudicated facts by 30 of June. But that I put it for your consideration. This concludes today's public hearing. I thank the parties and the Victims' Council and the registry for their attendance, and I also wish to thank the interpreters and the stenographer and the technicians from the audio-visual booth, and also the security personnel for their assistance. We will reconvene in a closed session with the SPO and certain units of the registry, and that will be, and I will have a short consultation with my colleagues, so I will turn Thank you for your short patience. We have decided that we will reconvene at today in closed session with the SPO and the units of the registry at 2:30, and we hope that everybody can be available at that moment in time.
Your Honor, may I ask a question?
Of course, you may.
Yes. So our further presence today is not required, I understand. And do I understand that tomorrow there will be no session where our presence is required?
Thank you, Defense Counsel. It's a pertinent question and a very good question. Yes, tomorrow your attendance at the court will not be necessary because we have finished our trial preparation conference in open session already today, and we had planned tomorrow in case of necessity, and we have been all very diligent and efficient.
Well, thank you very much, Your Honor. Much obliged.
The hearing is adjourned.
All rise.